All right, good afternoon, everyone. I am Sarah Diedrich Kasdorf, the Director of Outreach and Member Engagement at the Wisconsin Counties Association, and I have the pleasure of welcoming all of you to our first In the Boardroom of 2025. We have a great topic for you today on lake districts and a county's role. Before I turn it over to Andy and Rebecca, I just want to make a few quick announcements. First announcement is this webinar and the PowerPoint presentation associated with it will be placed on the WCA website under the WCA events tab shortly after this particular program is concluded. So hopefully by the end of the day, everybody will be able to access this. If you would like to go back and take a review of the webinar or a review of the PowerPoint presentation. The other thing I want to mention is we will be taking questions throughout the presentation. You can ask your question either through the chat or the Q&A feature on Zoom. For those of you who are not overly familiar with Zoom, you will find each of those icons on the bottom of your Zoom screen. Click on it and you will be able to type in your question in the chat or the Q&A. We will be monitoring the chat and the Q&A throughout the presentation, but I will tell you we have a lot of information to get through today. So depending upon the number of questions we have, we may stop and take a few questions as they arise. Otherwise, we will get through all of the questions at the end of this presentation. So with that, I think that is everything I had. And at this point, I am happy to turn it over to Andy Phillips and Rebecca Roker from Attolles Law to run us through this presentation.
Thanks, Sarah. And I'm going to start with just a very brief introductory remark, and that is in my 30 years working with counties and the WCA, that this issue of lake districts hasn't come up that often. From time to time, we get questions about district formation. We get questions about district organization and governance, but this isn't a topic that lands on everybody's radar every day. That said, I think that with the proliferation of community organizations and community associations, we're sure to see an uptick, I think, in lake districts and their importance as it relates to managing watershed issues, managing dam issues, managing other issues in the areas surrounding our Wisconsin lakes. Rebecca has a lot of information to get to, as Sarah alluded to, but I just want to highlight that pay particular attention because we're going to focus on the county's role in the Lake District formation, organization, governance process, and the county's ongoing role as it relates to the lake districts. Counties statutorily have a very important role. And so we think it's important to have this discussion today, but this discussion is not aimed at how do you form your own lake district. This discussion is focused on a county's role in this process. So as Sarah mentioned, feel free to ask questions as we go along. This is in the boardroom where questions are not only welcome, they're mandated. Ask us the questions that you have. But with that, I'll turn it over to Rebecca so we can get to some of the very important information she has to share.
Thank you, Andy, and thank you, Sarah. Good afternoon, everyone. As a brief introduction, I'm going to just flip right to our presentation overview. You'll see that number one is why this topic and why now. And just quickly looking at our overview, we're going to run through what, again, an overview of what lake districts are and are not, what the statutory authority is granted to lake districts, and what are the statutory requirements for formation. And all of these points that you'll see are really kind of summarized within our fifth item, which is the key points for a county's consideration. And then we'll talk about some of the resources available to counties and to others who have future questions or additional questions about lake districts. Again, jumping right in, as Andy mentioned, we have fielded questions about lake districts on our county team throughout the years. And as many of you know, Malia Malone, who is the former corporation counsel in Polk County, has joined Attolles, and she has dealt with lake district questions and issues quite a bit directly within Polk County. So an interesting insight from that perspective. Then we've received recently a lot of other questions. It was kind of this movement and sudden boom of inquiries about lake districts. So that's why we thought this would be an appropriate time to do it in the boardroom on lake districts. And so why? What is the trend? Let's look at from a global perspective what some of the issues are that are facing counties, because we think that these issues are directly impacting the number of lake district requests that are being brought forward. Obviously, counties have budget constraints. There is an ongoing deterioration of dams and other infrastructure throughout the state. Because of that deterioration, people want to know, well, who owns the dams? Who owns this infrastructure? And oftentimes, ownership questions are not clear. The DNR does their very best to assist in answering those ownership issues, but that can be a challenge as well. Another reason that we see these issues coming forward more, we think it's because of the continued restrictions on a county's ability to regulate waters of the state, which is, as you may know, the public trust doctrine, that the doctrine that all public waters belong to all of us. They belong to the state. And as such, a county is very much restricted on how they can regulate activity on the waters or related to public waters. One example we see a lot within Attolles and at WCA are questions about wake boats and wake boat ordinances. So that's just one example, again, of how a county's restrictions on the ability to regulate waters of the state, again, we think is one of the reasons we're seeing more requests for lake districts. And obviously the counties are responsible for many, many roles, from health and human services to maintaining jails. You've got a lot going on. You wear a lot of hats. And so we think, again, that is all of those different hats may be a reason that we're seeing an emergence in request in lake districts. So what are some of the challenges that property owners face that may be, and we think are some of the reasons for the increase in the request for the number of lake districts? Number one, rising costs of maintenance. There is no mechanism to force other owner participation or to chip in for maintenance of or for ongoing environmental protection projects. There's not a lot of tools to force other riparian owners or other beneficiaries of the lake to do certain things. Folks feel very restricted that there is such an inability to adopt rules and ordinances and other regulations for use of the lake. And again, that goes back to the public trust doctrine. So oftentimes community owner or community members and property owners will approach the county and say, can you please pass a wake boat ordinance? And because the county's hands are tied, that ties the hands of the public as well. And then finally, we hear concerns about lack of responses, not only at the state, but also from the local government levels, sometimes because hands are tied, and sometimes because there's a lack of information. But I think we've seen an emerging frustration from members of the public with respect to a lot of issues facing Wisconsin's lakes. So with all of that, those are kind of the trends that we see that are lending themselves to an increase in request for formation of lake districts. So while right now there are over 200 lake districts in Wisconsin, again, we're seeing a rise in the number of petitions. And we think that there's going to continue to be more because of the benefits and the statutory authority that lake districts have to address all of those problems that we just talked about from the public standpoint as it relates to the well-being of the lake. So let's do an overview. This photo briefly is of Lake Geneva in Walworth County. Lake Geneva was actually the very first lake district. It's my understanding it was formed in 1898. So it's a good illustration not only of a beautiful Wisconsin lake, but also that there is a rich history throughout our state of wanting to preserve our lakes and our public waters. And so we've got a long history of citizens coming together to try to address unique issues that face their lake or their local lakes. It has been a historical challenge that there's no central oversight authority. We know that DNR, under the public trust doctrine, is the holder of that public trust. But when we're talking about individual lake issues, there's really no oversight governmental entity that can provide the specific attention and the need that many property owners are looking for. And so then in 1959, several lake associations, and we're going to talk about the difference between lake associations and lake districts, joined together and formed the Wisconsin, that should be Federation of Lakes. And so that organization is still in existence, and it still plays an active role in terms of resources for people with questions. Then in 1974, the Wisconsin statute, or the Wisconsin legislature created Chapter 33. This was a new kind of lake management association, and it created the Public Inland Lake Protection and Rehabilitation District. And so with the formation or the creation of Chapter 33, the governmental entity that is a lake district was created and became a tool to address all of these specific issues facing individual lakes. So when we're talking about a lake district, we have to make sure we know what we're talking about. There are many different organizations that can address lake issues, such as lake organizations, associations, town sanitary districts have been used in the creation of boundaries around a lake to try and address the issues. There are task forces and wonderful conservation organizations throughout the state who oftentimes step up and work to try to protect the lakes and restore if needed. Also under Chapter 33, DNR is allowed to develop and fund lake protection and rehabilitation projects. So those are individual projects, and with that term, we think there's a beginning and an end. And then finally, we've got the Public Inland Lake Protection and Rehabilitation District. This is what we're talking about today and what I refer to as a lake district for short. So we're going to be talking about these governmental entities that are specialized with distinct powers and authorities that are created under Chapter 33 of the statutes. So what are some of those unique characteristics? Again, always remember, folks, that a lake district is an independent governmental body. And so it comes with a lot of power and a lot of authority, and also, in my opinion, great responsibility. And so keep that in mind as we're talking about all of these issues. And again, because it's a governmental body, it has certain governmental powers that we're going to talk in more detail about in a minute. Another unique characteristic of a lake district is it's led by a board of commissioners that's initially appointed by the county board upon creation or upon formation. And then those the property owners who are within the lake district can then elect representatives to that board. An interesting component of lake districts is that you do not have to be a resident of that boundary area. You just have to own property. That is a unique characteristic exclusive to lake districts throughout Wisconsin. Lake districts have taxing authority. They have the power to levy and collect taxes and special assessments. That is a significant authority that oftentimes raises issues and questions from people. And then finally, they have the ability to create ordinances and then also to have enforcement bodies and then processes to essentially prosecute those ordinance violations. So again, significant authority that is granted to a lake district as a governmental body. All right, so now let's go into a little bit more details, and we're going to reference the specific statutory sections of where these powers and authority come from. Again, in case you want to go back and refer to these statutory sections, we've got the references here. And again, always keeping in mind that these are governmental entities. So a lot of these powers and authority are similar to what towns, county, villages, other sanitary districts or other governmental entities have. So what are those? They can sue and be sued, can enter into contracts, they can accept gifts and donations, they can appropriate money. Financials are big, and in section 33.31 and 33.32 specifically address Lake District finances. They can borrow money. Then we've got this very broad provision that says a lake district can use any other financing method prescribed by law. Can't get much more broad of authority than that clause when it comes to financial components. And then number 3, they may levy an annual tax to pay principal and interest on outstanding debt. And so because a lake district can borrow money, they then also have the ability to levy tax in order to pay the principal and interest of that outstanding debt. And then they can levy special assessments. And again, this is very broad. They can levy special assessments for the purposes of carrying out district protection and rehabilitation projects or for other lake management activities. That's pretty broad. So if you've got, if the purpose of a specific activity is to carry out, is to conduct a project for the lake district or to carry out lake management activities, the district can levy that special assessment. All right, what are some other authorities granted? I touched on these before, but again, I wanted to make sure that you all had a comprehensive list to refer to. In section 30.77, sub AM1, I referenced the ability to regulate boating activities. There are some limitations in this statute that are placed on a lake district's ability to regulate boating activities through the adoption of ordinances. Now, keep in mind, we still have to operate under the public trust doctrine. And so that's why some of those abilities to regulate exist. In some instances, there are requirements of underlying municipal approval of those ordinances. Now, those restrictions do not apply if the lake district is formed by the county. So again, kind of that separation of a county's ability to regulate certain boating activities. But for purposes of our discussion today, just the takeaway should be that a lake district does have authority to regulate boating activities, and I would say a greater authority than counties do under the statute. Again, making them very attractive for folks who may want to regulate a lake. They also have the ability to adopt regulations of seaplanes. Interesting component of this section is that a lake district's ordinances can actually trump other municipal ordinances. So that's an indication of how much authority a lake district has. And then under Chapter 66, because Lake District is a governmental entity, many provisions of Chapter 66 of the statutes apply. A lake district can adopt and authorize the use of citation for violation of those ordinances. They can commence an action for violation of the ordinances. And they can also create water safety patrol units, which are law enforcement units that can enforce the ordinances. So I should probably stick number 5 above the provisions of 66, because the law enforcement usually comes before the issuance of the citations. But that is a significant authority. They can create, the lake districts can create these safety patrol units that are law enforcement bodies. And then finally, again, because a lake district is a governmental entity, they can enter into intergovernmental agreements under Chapter 66.0301, which is very important from the standpoint that that happens somewhat frequently throughout the state, particularly depending on the size of a lake. Or some of the complex issues facing the lake, the population density of the area, you will oftentimes see lake districts enter into intergovernmental agreements with neighboring municipalities or other local government entities. Okay, what must a lake district do? As I mentioned before, with great authority comes great responsibility, right? So, as a governmental entity, Wisconsin's open meeting laws apply. Wisconsin's public records law applies to lake districts. So anytime a lake district upon formation has a meeting, they have to ensure that it complies with all of the open meetings laws. That's a big responsibility. All of their records are deemed public, well, not all of the records, but they're subject to public records law. And so they have to field public records requests. Another important restriction on lake districts' authority is they have to follow the lowest responsible bidder process, and that's in Chapter 66 of the statutes. If the contract is greater than $2,500. So that would apply to many different restoration projects or algae treatment. That is very frequently something that we see in terms of one of the goals of a lake district. So when you are ready to enter into that type of contract, you got to follow the public bidding process. And then finally, the board commissioners must comply with the ethical requirements for local government officials. Again, because this is a governmental entity, the Lake District, it's a governmental entity, its board commissioners are local government officials. And so there has to be a focus on maintaining and adhering to those ethical requirements that apply to other local government officials. All right, so now we're going to talk more specifically about a county's role and a county's involvement throughout the creation and the formation of a lake district. Before we do that, now I'm kind of sidestepping, it is really important for county officials to understand what a lake district must have a purpose, and it must meet all of these other statutory requirements, because when a county is asked to form a lake district, the county is responsible for making sure that the petition includes all of these items. And so when a county is presented with a petition for a lake district, the petition must set forth a purpose. Under the statutes, the definition is that a lake district may be created for the purpose of undertaking a program of lake protection and rehabilitation of a lake or parts thereof within the district. UW Extension, and I'm going to touch on their incredibly helpful resources when it comes to lake districts. They say it what I think is a different and more clear way, that the purpose of a lake district is to maintain, protect, and improve the quality of a lake and its watershed for the mutual good of the members in the lake environment. And to me, that is a really all-encompassing definition. And when you talk about lake environment, you know, sure, there is the actual lake. There are the riparian owners who have property along the lake, but that lake environment can extend beyond just those two areas. And so the purpose of a lake district can extend and address issues that go beyond just those outlines of the water. So how do we form a lake district? And again, we are focusing on the county role and the formation of a lake district when a county is presented with that request. So who can petition? Anybody. Anybody can petition. Usually it will be a group of lake owners or people who have a high interest in the lake who will put together that petition and request the formation of a lake district. Chapter 33 is very clear that the formation process has to be complied with, and there are specific requirements set forth in Chapter 33, which frankly act as a good guide for that formation process. Keep in mind that the city, village, and town may also create a lake district. However, the process is different. It's much more streamlined than if a county is requested to create a lake district. It's a less complicated process. There's less verification required. And then in the end, the governing body that the Board of Commissioners is that municipal entity. So it will be that the Lake District Board will be made up of elected local officials, which is very different than a county-created lake district. So right off the bat, who is doing the formation drives what the effect is and how that lake district is going to be governed. And again, we're going to obviously focus on the county's creation of a lake district. And interestingly, from a statutory standpoint, Chapter 33 really focuses on a municipality creating a lake district, city, village, town, not a county. But then there's this specific carve out in 33.24 sub 2 that allows a county board to create a lake district. So again, interesting from a statutory standpoint that there is a very distinct process that a county must follow when it's requested to form a lake district. 33.24 language is very direct. The county board may form a lake district. That should be if the requirements of 33.26 are found to exist. The reason these are underlined is because each of these phrases or words create specific obligations on the county when it is going through the formation process. And even though I think the statutory intent is that the onus be on the petitioners when they're asking for creation of the lake district, the reality is that a county is also taking on a great obligation and responsibility when it's being asked to create a lake district. And again, why? Because lake districts are governmental entities that have power and authority. And so therefore, when a county is asked to create one of these governmental entities, these obligations in that formation process become very, very important. So the first requirement in 33.25 is the actual what must be contained within that petition. And again, usually we see a formation come of a group of citizens, concerned citizens, who will prepare a petition and bring that petition to the county requesting formation of that lake district. The petition must be filed before the county board takes action. So that is a legal prerequisite for the county board to take action. A county board cannot just create a lake district because it thinks it might be a good governmental tool. There has to be a petition filed in order for the county to create a lake district. Again, that is one of the significant differences between county authority and other municipal authority when it comes to lake districts. Number two, the petition must be signed by persons constituting 51% of the landowners or other owners of 51% of the lands within the district. This is one of those elements that should be straightforward, oftentimes is straightforward, but may not be. And when a county is faced with challenges to a lake district, oftentimes the signatories and whether that 51% threshold was met becomes an issue. A municipality can be included in the boundaries of a lake district if they approve and they sign off on that. And then there are specific statutory rules that apply to corporate or other trust owners of property and who can sign on behalf of that trust or who can sign on behalf of that corporate owner. So again, all of those considerations are important when we're trying to determine whether that 51% threshold has been met. The petition has to include specific information. And these elements are specifically set forth in the statute, which is very helpful and very clear in terms, again, of what that petition has to include. It has to include the name of the proposed district. It has to include a description of the necessity. What is the purpose of that proposed district? Then it must include information to establish that the public health, comfort, convenience, necessity, or public welfare will be promoted by the establishment of the district. So this is one of those more nebulous requirements in terms of what is going to promote public health, comfort, convenience, etc. What is it? What are the reasons that are needed for this lake district? So the petition has to include all of those reasons. Obviously it could include a summary of reasons, but it should include enough information to establish what is the purpose of this district and how is that district going to benefit the public health and welfare. Number 4, the lands to be included in the district must be referenced. And so this is where we I skipped ahead to the boundary element. I'll skip ahead anyway. The boundaries and that outline of the lake district has to be included within that petition. And again, jumping back, the lands to be included in the district must be benefited. Now, this element is one of the elements that actually has been litigated in Wisconsin. And so we do have some case law to give us some insight into what is a benefit and how that term benefit is to be legally construed. And we're going to touch on that shortly. But I just want you to have a list of what all of these petition requirements are before we break them down. Okay, so a group of people got together, formed this coalition to put together a petition. They got their signatures, and now what? They drop it off at the county clerk's office. This is the entree to the county's involvement in that creation process. So the statutes require that the petition be verified by one of the petitioners. And so this is the statutory intent that the burden be shifted to the person or that group submitting the petition in order to verify and essentially promise that, yes, all of the information in this is correct, is honest, truthful, accurate. However, who checks that? This is where the statutory intent may be that the onus lie with the petitioners, but the county has to verify the information as well. And so the reality is when a lake district petition is submitted to a county, you can bet that there is going to be a lot of staff time, effort, and work put in. Again, the extent of that staff time, effort, and work depends on a lot of different factors. How high quality is the petition to begin with? How big is the district? Is it controversial? I mean, all of those different elements. But we've seen situations where there is a tremendous amount of staff time committed to a Lake District petition. And we've seen others where there's been minimal time. And so again, it depends on lots of different circumstances. But again, message being, if the county receives a petition, you can count on the fact that there's going to be some staff time involved. Okay, in terms of that verification element, again, as I mentioned, the statutory intent is that the onus be on the petitioner. And sub 4 of 33.25 actually says that every petition is presumed to have been signed by the persons whose signature appears until proved otherwise. And so again, in situations where you may have public objections to the petition, the verification of signatures will be attacked, thereby trying to overcome that 51% threshold. And so people will, or opposition will often focus on whether the signatory actually owned property, whether that signature is accurate, whether one person signed 5 petitions under different names and so forth. So this statutory section says that every petition is assumed to be, or is presumed to be accurate unless proved otherwise. So that creates essentially an evidentiary onus for someone to come forward and set forth evidence that the signatures are not valid. This is one of those situations where a county looking at and trying to verify signatures can indeed rely on that verification from one of the petitioners. And so unless a county has evidence in front of it that there are errors or a significant information to establish that those petitions are not valid, it doesn't have to go on an independent investigation as to the validity of those signatures. A county can indeed rely on that verification from the petitioner. So we do have one case, the Nielsen case from Waukesha County. I believe that was a 1993 case. And the issue in that case was, what are the requirements for that verification? And the court said that when a petitioner verifies that petition, if it's made under oath, it carries the authority of a notary public. And therefore, the person giving the oath may be relied upon. And again, that's where we get to the element of the county may rely upon that verification from the petitioner. Importantly, this court said that there's no difference between certification and verification of a petition. And that's important because I think it gives us an insight to a court's focus on, was the statutory intent met? Even though in this case, the petitioner certified that the petition was accurate and correct. The statutory language uses verify. The court said those are the same things. And again, so I think this case is important that we really hone in on what the statutory intent is. All right, let's talk about the boundaries. The boundaries have to be included in the petition. There's lots of questions as to how those boundaries are created. And again, the purpose, you have to look to the purpose of the proposed Lake District. And in order to meet that purpose, who should be included? What properties should be included? Guidance from the UW extension says that all riparian owners, it's pretty much a given that they should be included. Off-lake property owners that benefit from the lake or the effects of the lake should also be included. A district can include more than one lake, which is an interesting component, depending on the geographical makeup of the area. And again, a city or village has to approve its inclusion in a lake district boundary. Okay, so now there is a specific process in the statute that the county must follow once it receives that petition, goes to the county clerk's office, then what? So the first step is that after submission of the petition, the county board must arrange for a public hearing not to be held later than 30 days after submission. So again, key point is a public hearing must be held not later than 30 days after submission of that petition. The county board appoints a committee to conduct that public hearing. And oftentimes a county will already have a designated committee. Usually it's your land conservation committee or your planning and conservation committee. And that committee will hold that public hearing. There are specific public hearing notice requirements in 33.26 that all must be adhered to. And the purpose of the public hearing is very important because it must give all interested persons the opportunity to offer objections, criticisms, or suggestions. That language is actually in the statute. And so to me, that illustrates how important the legislature felt when creating these governmental units. There must be a robust opportunity for the public to voice their opinions. And so certainly public hearings are always important when required under the statute, and public participation is always important. But when creating a lake district, this public hearing takes on an even greater importance, in my opinion. And so as a result of that public hearing, well, then obviously we conduct the public hearing. But then what happens after, again, I think this is a unique statutory component that we don't often see when talking about the dynamics between either a committee's work and then a board's work. But here, after the public hearing, the committee has to report to the county board within 3 months after the date of that public hearing. So what does that mean? What is it to report to the county board? We recommend that when that committee reports to the county board, that you look at the elements of the statute that must be met in order for that lake district to be created. Those elements should guide what is in that report. I listed some examples of what should be included in a report. Again, always hit the information supporting those items that are necessary under the statute. But then you can also include the number of people speaking for or against. You can include other details or evidence about the purpose. There may, again, there's a plethora of different items that may be unique to a lake district, and all of those important elements establishing the purpose and how it's going to support public welfare should be included in that report. Then the report goes to the county board, and again, under 33.26, that report has to go to the county board within 3 months after the date of the public hearing. So again, another landmark time benchmark. So goes to the county board. Then within 6 months after the date of the public hearing, the county board has to render a decision. This is the part of the statute where the county's responsibility is the most important, because it must render certain findings. Keep in mind that a decision whether to form a lake district is deemed a legislative decision under our case law, which means the county board is given great discretion. However, within the statute, the county board must also utilize the evidence presented to support that decision. And so usually when we talk about a county board's ability to make a legislative decision, we don't talk about evidence. I mean, yes, there has to be information to sustain that decision, but because of the great discretion that's given to county boards and legislative decisions, we're not usually talking about reports or evidence. Here we are. And so the county board It has to look to the committee's report and any other evidence submitted to the board. What is the evidence? That is the evidentiary record of all of the public comments, again, the committee's report, other submissions, other statements as to the purpose. All of that information becomes the evidentiary record. That is the basis upon which the county board should make its decision. If the county board finds that the required elements of the statute are met, then it shall create that district. Again, it's a legislative decision, so it's given, the county board's given great discretion, but there's still this element of specific evidentiary requirements and specific elements that the county board is to look at when it's making its decision. So what are those? The county board has to find that the petition is signed by all of the requisite owners, that 51% threshold, that the district is necessary, that the public health, comfort, convenience, and so forth will be promoted by the establishment of the district, that the property included in the boundaries is going to benefit by the establishment of the proposed district. And then if all of those elements are met, based on the evidentiary record, the county board by order declares its findings. It establishes the boundaries. It declares the district organized. It declares what its name is. And again, that name is included in the petition. And then the county board establishes the initial Lake District Board of Commissioners. So again, remember, the Board of Commissioners is that governing body of the Lake District. So once the county board creates the Lake District, it appoints the initial Board of Commissioners. Oops. Again, I probably sound like a broken record at this point. The key takeaway here is a Lake District is an independent governmental unit or body with specific powers and authority. And that is why the onus placed on counties when it receives a petition for creation of a Lake District is so great, because the county board is creating an independent governmental unit when it goes through this exercise of, again, when it receives a petition for the creation of a Lake District. All right, quickly shifting. How are we on time, Sarah? We're okay. I'll zip through these, so again, we can circle back on some other key issues faced by counties. Again, briefly, Lake District is governed by the Board of Commissioners. There is a county board member, or there must be one county board member who is either a member of the statutorily required Land Conservation Committee or is appointed by that committee. So there is some county board representation on the Board of Commissioners. One person is appointed by the governing municipality within which the largest portion of the valuation of the district lies. So if you've got a district that lies in two different municipalities, you look to the one that has the largest value of land. And then there's 3 electors or owners of the property within the district. At least one of them must be a resident of the district. Keep in mind that non-residents can still vote on matters involving the Lake District, but there must be at least one representative on that commission that is a resident of the district. And again, the last point is that Lake Districts are very unique, that eligible voters are anyone who owns property within that district. You do not have to be a resident of that district. There are lots of things that the Board of Commissioners are responsible for. And I'm not going to go through these in detail again, because we're focusing on what the county's obligations are. But again, this is important to the extent that it should be considered when a county board is asked whether to create a Lake District, because these responsibilities and these obligations of the commissioners come into play once the Lake District is indeed created. So these are a list for your reference. And again, I love this quote: with great power comes great responsibility. It's originally from Voltaire, but it was also from Peter Parker, as somebody pointed out to me from Spider-Man. Okay, now let's talk about how some specific county considerations and some specific issues that we've seen counties face when presented with a petition to form a lake district. The verification, again, I talked about how the statutory intent and the specific statutory obligation is on the petitioner to verify that petition. However, who verifies that? The real life is that the county has to verify that verification, right? And so even though the statutory intent is that the verification onus be on the petitioner, there is very much an impact on the county resources when it receives a Lake District petition. Is there liability that accompanies that verification process? In our legal opinion, the easy answer is no, to the extent that the law is clear that the county may rely on that verification, again, by the petitioner. And again, the language of the statute is such that does not require you to do an in-depth investigation as to the information contained within the petition. You are able to rely on it unless there is evidence demonstrating otherwise. Boundary determinations. Oftentimes, counties will be faced with comments from the public one way or the other in terms of who is to be included in this lake district. Again, statutory intent is that the petitioner develop that boundary included in the petition. And so again, the onus being on that petitioner. In reality, you as elected officials are going to be fielding those emails and calls from concerned citizens about what it means to be included in that lake district. So there is an element, there's an obligation on the county when looking at what these boundary determinations are. The other important element of this is that the county board can actually modify which properties are included or not included within that boundary. And so after the public hearing, after the committee report, when the petition goes to the county board can make adjustments into or as to which properties are included or not included. That being said, the case law indicates that it is not frequent that the county board will modify those property boundaries. And there's also case law that says the county board is not obligated to remove a property owner or a property from a district simply because the owner requests removal. So as public officials, when you are inundated with requests for removal of a particular property from a district, keep in mind that you are not obligated to remove that property, but you should look at all of the evidence in front of you to determine, again, whether there is a benefit to that property and whether all of the other circumstances dictate whether that property should be included. So what's a benefit? We fortunately have some case law on what a benefit is. We can look to economic benefits. We can look to the preservation of property values. We can look to a person's ability to enjoy the lake. We can look to other economic opportunities, such as does the lake draw commercial business, tourism, all of those elements. Case law also tells us that you look to the district as a whole when determining the benefits. And so when you're looking at the boundaries as a whole, what are the benefits to the district as a whole? Now, this is an element where the case law says you look to, or I'm sorry, the statute says each property included in the district is going to benefit. Case law says you can look to the district as a whole. So if you have a property owner that is requesting removal upon, within the creation process, you can look to the benefits of the district as a whole when deciding whether to remove that property owner. Okay, may a county board restrict the authority of a lake district, such as removing the power to levy taxes? No. The county may not adjust or otherwise add to or remove a lake district's authority when it is creating that lake district. The statute set forth what the lake district's authority is, and the county can't change it. The only thing a county board can do is make adjustments to those district boundaries. So if you are faced with public concerns over the lake district's ability to levy taxes or special assessments, that is not a power that the county board can take away in the creation process. So what do property owners have as remedies? So when you're fielding these calls or emails from concerned citizens, we are often asked by counties and the public officials, well, what can we do for these people? Again, a board as a whole may remove certain properties from that boundary within the creation process. But it's also important to remember that after the lake district is formed, there is a process available for a property owner to be detached from that district. And that process is set forth in 33.33. So keep in mind that once a county board creates that lake district, it's not as if the property owners who didn't want to be a part of it are tied to it forever. There is a statutory process that allows for a person to request detachment. So after a county creates a lake district, what are its obligations? What happens next? The great thing about a lake district, in my opinion, or one of the great things about a lake district, is that many of the obligations that would otherwise fall on the county now fall to the lake district. So even though there's that continued representation by a county board member on the Board of Commissioners, many of the elements or the questions that would come to a county regarding water quality, or again, that infrastructure, dam ownership, dam repairs, all of those elements can now be tackled by the lake district and not the county. Oftentimes, we will see cooperation between counties and lake districts or other local units of government, but there's no obligation that a county cooperate or participate with that lake district. Now, of course, we always want to encourage that cooperation, but keep in mind when considering whether the county board should create the lake district, there's oftentimes questions of, well, what's the county's ongoing obligation? There's not many. Liability questions. Oftentimes we're faced with, okay, so the county approves the creation of the lake district. What if something happens? Is there ongoing liability? And the easy answer is no. All of the rules of governmental immunity still apply. There's no case law indicating that a county has been deemed liable for any sort of future damages by virtue of creating a lake district. And again, I touched on what are some of the potential benefits to a county. There can be, again, those shift of obligations. The Lake District is able to focus its resources on those particular lake issues. Again, the county wears so many hats and has so many required elements in the statute that it has to attend to. An individual lake will then be able to be focused on by this lake district. And so that takes the onus off the county. And then we always see that greater public involvement, particularly in a group of citizens that feel very passionately about a certain cause, i.e. protection of this lake. that increased public involvement oftentimes results in better relations between local governments and the public as a whole. So that is certainly one of the potential benefits if a lake district is formed. Important resources briefly. If you have any follow-up questions, of course, you can contact me and Andy, but there are some phenomenal resources promulgated by the UW Extension and the University of Stevens Point through the College of Natural Resources has a specific program, the Extension Lakes program. I included their website, and then there's some links on the next page. The text People of the Lakes, a guide for Wisconsin lake organizations, is a great one-stop shop for a summary of all of the different potential lake organizations or associations, lake districts, etc. And then it also includes great details in terms of the steps that we talked about today, within the process. And then again, here is the direct link to the Extension Lakes programs. Wisconsin Lakes, you might remember, was the 1959 first official lake association, and then the DNR. The DNR plays an important part. We didn't really touch on that today, but again, as the holder of that, the public trust resources of our public waters, DNR obviously plays an important role. So we're finally to questions. Miss Sarah, I don't know what our time looks like for questions. If we have time for questions, we can stay on a few minutes. Andy, I don't know if you're available to stay on for a few minutes.
I was going to say, Rebecca, we can stay on as long as you are available. I don't know what your time constraints are or Andy's time constraints are.
Yeah, I can definitely stay on. I could like for 15 more minutes if we, depending on how many questions we get.
That sounds good. Rebecca, can you see the questions at all?
I can't.
Okay. All right. Well, then I will start going through the questions for you, and we'll get through as many as we can with the time you have available.
Okay.
All right. So the first question, can public lands within a district, such as county property, be assessed expenses of the Lake District, not as a tax, but as a special assessment?
Great question. I think you would look to the underlying rules of special assessments within the statutes. So whether counties could be assessed, I don't think so, but I don't know that for sure. That's going to be one of those follow-up questions, because I certainly don't want to guess at the wrong answer. But again, you first look to the underlying statutory limitations on whether a special assessment could be utilized against that, the governmental entity in question, whether they could be assessed against a county for, say, county parklands. Now that I'm thinking through this and talking out loud, I don't think so, but again, I can secure a more firm answer to that question.
All right, on to the next question. You mentioned that lake districts can create and adopt ordinances. Can an ordinance be more strict than state statutes, such as regulating wake boats and shoreline zoning?
Great question, and the answer is a lawyerly answer of it depends. On certain topics like seaplanes, the lake district's ordinances may be more restrictive than the other local rules. In terms of restrictions on, say, activities in the shoreland area, no, because the state statutes are clear that the what the standards are for shoreland zoning and activities within that shoreland area. And so, no, I don't think a lake district would be able to adopt a more restrictive, say, shoreland code than what's set forth in the state statutes.
Okay, this is a two-part question. If the county board denies creation of a district, is there an appeals process? And what are the justifiable reasons a board can deny creation of a district?
Okay, I'm going to take the second part of that question first. Again, the county board is tasked with a very specific list of what it must find based on that evidentiary record. And it's those five, let me pull up my statute, those five elements that need to be included in the petition. That's a good guide. So for example, if the county board feels that there is sufficient evidence that that 51% threshold is not met, it can deny the petition for that reason. Let's say that the county board has concerns over the overall public health and welfare being benefited by the creation of the Lake District. If it's got that evidence in front of it, the county board can use that as the basis for not creating the Lake District. So again, it's the information and facts of a particular situation and a particular petition brought in front of the county board that's going to derive the reasons it can deny. But again, this is a legislative decision, so the county board is given discretion. Again, we've got that element of utilizing the evidence, so that record is very important. So I know that that's kind of a mixed message, but what my advice to county board members is look at what is in your record, look at what's in your report. And if you've got concerns about creation of that district, does the information in the report support not creating the district? That's really the approach that you should take.
Okay, I'm going to try to switch here between stuff in the Q&A and the chat. Has a Lake District ever been dissolved in Wisconsin?
Not that I'm aware of. There may be ones that were formed prior to the adoption of Chapter 33 that either reformulated to be a Chapter 33 Lake District, but I'm not aware of any that were created and then dissolved. The reason being, if you've got a limited purpose for which the district would be created, you can, there can be that process of the Public Inland Lake Protection and Rehabilitation Project. So if there is an issue driving the creation of that lake district that is a limited scope, you don't have to create a lake district. You can petition for DNR to create that project in order to address that particular issue.
Okay, what is the best practice on how the board chooses who each county rep is who sits on each lake district?
Best practice, I would say, well, the statutes require that it be either a member of your conservation committee or an appointee. I would say somebody who is familiar with conservation issues, water quality issues, has a interest in the issues that are driving the purpose of that lake district. So is it contamination? Is it recreational concerns? Somebody who, one of the committee representatives who has an interest in those issues. There are no specific statutory requirements placed on that county board committee member of the commission. So I can't really identify any best practices in terms of other performance requirements of that committee member. But again, it has to be somebody from your conservation committee or another appointed person from that committee, and somebody who's interested in the issues. Maybe it's somebody who is close by or whose supervisory district is within that lake district. That would I would think be a good practice.
Okay, can the county board adjust the district boundaries from those in the petition during the formation process?
It can, yes, and that is one of the privileges of the county board that is significant within Chapter 33. While I will warn, though, that even though the county board can adjust the boundaries, the question is whether it should. Case law indicates that it is not very common that the county board does make those adjustments. From a legal standpoint, that's an important point. And keep in mind that the onus on the preparation of the petition and the development of those boundaries is supposed to fall to the petitioner. So once that boundary is established by the petition, the county board should be able to rely on that. And so if the county board chooses to exclude certain properties, I highly recommend that it have good reasons to do so. And again, keep in mind that the law does not require that a property be excluded simply because the owner requests it. So that gives county board members a little bit of guidance as well in terms of what their obligations are.
And what I believe is a related question, can the county add properties to the district that would benefit but were excluded to meet the 51%?
That's a great question, and it depends on when that occurs. At the county board meeting, when the petition has gone through the process, the county board cannot add properties that were not included in the original petition because those properties were not included as part of the public hearing process. So from a procedural standpoint, again, the underlying goal of that public hearing is to have robust public participation. If a property owner was not included in the original petition, but then added at the county board level, that owner is being excluded from that public participation process. So again, the county may add properties to that boundary, but it has to occur prior to the public hearing.
Okay, a question on levying. It was mentioned that a lake district may levy to pay principal and interest due to borrowing. It was also mentioned that special assessments may be assessed for lake projects and maintenance. May a lake district levy a tax for lake projects and maintenance in lieu of special assessments?
Yes, I think it can. I don't think that if you have let's say you have a rehabilitation project that needs to be funded, I don't think that the Lake District is limited to a special assessment. I think it can use its taxing authority to do that.
Okay, and then another question here on the special assessments and levies. When or why does a Lake District use a special assessment charge to add to the tax bill versus filing a levy with the state?
That's a great question. I don't know. I'm trying to think of an example of when we've seen the special assessment authority used. Often, I guess the most frequent one that comes to mind is if it's for a short-term limited purpose. So it's a one-time event or a one-time project that is again for a definitive period of time. So 1 year there will be a special assessment. Perhaps if there are needs that only impact a particular number of property owners and it's not district-wide, that there will be a special assessment rendered to those property owners that are actually benefiting from what is being paid for. Those are the best two examples I can think of. It's very important to remember that the Board of Commissioners who takes the action to whether levy that tax or specially assess, those are public decisions, and the public and the members of the district can participate in those meetings when those decisions are made. So they're not made behind closed doors, they're made in public meetings. And that is a key thing for not only owners, but county officials to remember, because again, when a lake district is created, it is creating a governmental entity, but county board members and county officials should also remember that there is a process that occurs after, and there are legal requirements that must be met after that creation, when those powers are exercised.
Hey, Rebecca, how are you on time?
I can go a little longer.
Okay. All right. Can a county take the ability of the district to monitor and ensure compliance with regard to septic systems?
Can you repeat that one more time?
Sure. Can a county take the ability of the district to monitor and ensure compliance with regard to septic systems?
So can the county take on that responsibility of the district?
Yes, I believe that's what the question is asking.
Okay, I think we have to back up a little bit, because the question, the other question might be is, does that burden shift to the Lake District? The oversight of sanitary sewer and like, for example, for Pouts licensing falls to the county under the statutes, and then the county acting as an agent of the state to enforce state requirements. I don't think that upon creation of a lake district that immediately that obligation flows to the Lake District. And so I don't even know if we get to the question of whether the Lake District can assign that back to the county.
Okay, I'm sorry, I'm flipping through questions here.
That's okay.
For some new questions. Let's see here. What would happen if the county board removes lands from a proposed district's boundaries during the formation process, which would lead to less than 51% of landowners signing the petition? Would the petitioners have the opportunity to recirculate their petition to gain the appropriate number of signatures?
So again, second part of that question, answer first, is yes. If the county board, in that instance, if the result of the boundary modifications are less than that 51%, I don't think there is enough of a reason for the county board to create that Lake District and exercise that discretion. If the Lake District is not created, folks can always file another petition. Absolutely. There's no time prohibition included within the statutes or time element that someone must wait 5 years prior to filing another petition for creation of a Lake District. So if one petition fails, yes, a group may come back and ask again.
And related to that, I think the question, and it may have been asked earlier in a multiple part question, is there an appeals process if the county board denies creation of the district?
Oh, yes, I think I did not, I don't think I answered that question. Yes, there is. There is no, I'm not aware of a specific process within Chapter 33. Let me check my notes here. But there are the other legal remedies available, whether it be petition by writ of certiorari to the circuit court. It could do that. Now, keep in mind, though, the decision to deny creation is a legislative decision. So all of the legal restrictions on challenging a legislative decision apply. And so the person appealing the county board's decision is going to have an uphill battle because courts don't like to overturn legislative decisions unless there's something clearly erroneous, illegal, arbitrary, and capricious. So it would be an uphill battle for someone to appeal a county board decision on the formation of a lake district.
Okay, there's just lots of comments in the chat here. I'm trying to look for the questions, but there are some comments about what special assessments have been used for. Some say special assessments are common for garbage pickup by lake districts. Lake districts use special assessments as a flat fee per parcel because the math is easier to explain. Let's see. Okay, I'm just looking here. There was a question about whether or not we are aware of any recent petitions being denied or any lake districts that were dissolved? I don't know if you know of any denials recently.
I don't. No, but I see from the chat that Eric Olson is on, who is in my opinion, the state's best resource when it comes to information for lake districts. Eric is with the UW Extension, and Eric, I am sorry, I did not have a chance to reach out to you before our presentation. I did include the conference website that you shared with me in March. It's on our last slide. At least I think it should be on there. If not, I will add it. So folks, for all of these questions that you have, and obviously there's lots of them, I highly encourage you to check out the UW Extension and Stevens Point Lake Extension Programs resources. Chances are you'll be able to find answers to your questions within their materials, or Eric may be able to answer those questions. And there is so much information and details to be shared about lake districts. Again, our goal is to share those legal requirements and the legal aspects of what a county board's obligation are. But all of these other questions are very good ones. And you may be able to, chances are you're going to be able to find the answers, through the UW Extension's resources.
All right. Are you out of time, Rebecca, or do you have time for?
Well, let's do 5 more minutes.
All right. All right.
I think somebody will come knocking on my door if I'm needed elsewhere, but.
Okay. Yep. All right. I've got a few more questions here. Does the county board have an obligation to financially assist lake districts for sediment removal?
No, not that I'm aware of.
All right. When the county board is considering approval of a lake district, should a supervisor who lives in the proposed district abstain from voting?
Read that one more time, Sarah.
When a county board is considering approval of a lake district, should a supervisor who lives in the proposed district abstain from voting?
Well, now we get into analysis of the ethical obligations and the obligations of public officials under the statutes. And keep in mind, even if there is not a specific reason that that clearly checks a box of some sort of conflict, appearance is always very important. And so I would say that if that county board member is to be included in the district, their property is to be included in the district, my inclination would be to abstain. If they are just the board supervisor of that district in which the supervisory district in the lake district is in that supervisory district, I don't think that would be enough to immediately cause an abstention on the vote. But again, that's going to be so factually driven that those are kind of the best general outlines I can give.
Yeah, and if I channel my inner Andy Phillips for a moment, Andy would likely recommend that you check in with your county corporation counsel for on that.
Sarah, you make such a good point that all of these questions, work closely with your corporation counsel. I'm sure your corporation counsel is going to be involved in that petition process. From our standpoint, I think a lot of the reasons that we are seeing an uptick in the questions that are presented to Attolles on lake districts is because the questions are becoming more complicated. But oftentimes your corporation counsel will be able to address a lot of these questions and guide your county through this process. So absolutely consult with your corporation counsel on all of these issues and make sure that corporation counsel is involved in the process.
All right, let's see here. Does each titled landowner get a vote in district meetings, or is it just one vote per parcel?
It is, I believe it's one vote per parcel in the district meetings. Let me check that. I believe that's the case. Eric, you're on. It is per owner. So if you have, but the statutory restrictions of the relating to the corporate owners or the trust owners also still apply. So if you have two, okay, so Eric said corporations and trusts assign one person. So if you have two owners on a deed, let's say husband and wife each get a vote. If you have one corporate entity or one, limited liability entity is the owner, that gets one vote.
All right, let's see here. There's a question. What is the trickle effect on bars in resorts on a lake district? Does a lake district affect tourism?
A very individualized question. When you think of what the purpose of a lake district is, it is geared towards the addressing specific issues impacting the lake. Lakes are tourism draws. If you have a lake district that is addressing negative components of that lake, whether it be contamination, excessive recreational activities, whatever it might be, I think improving the lake and that lake environment is going to be beneficial for having people to want to come to the lake and therefore be beneficial for tourism. To me, there's a logical connection between those two. I don't think there's any sort of studies, and Eric, please jump in here if between the creation of a lake district and a either direct increase in tourism or a direct decrease in tourism. I think it's more appropriate to look at it from a more holistic standpoint and improving the nature of the lake and that lake environment and what impacts that improved lake environment are going to have. If a dam creates a lake and the district rebuilds the dam, businesses generally benefit. Yeah, I would totally agree with that. Because again, if you are improving the condition of the lake, it is going to draw more people to the lake, and that is going to benefit local businesses.
Okay, and Rebecca, I think we have kept you almost 30 minutes.
Yeah, I
at this point,
great questions. And Andy and I are here. And Eric, thank you for joining us. And let me just, I think I can, I'm still sharing maybe. But even if not, in the PowerPoint presentation, Sarah, that you're going to post, there are the links to the Extension Lakes Programs website. Again, great resources. The People of the Lakes text is a phenomenal resource to answer many of these questions. So I encourage people to use those resources.
All right. And so Rebecca, to you and Andy, thank you so much for joining us today and putting on this very informative webinar. I believe we got to most of the questions today. If I didn't get to your question specifically, I believe it was an iteration of a question that had been previously asked. If not, again, Andy and Rebecca's contact information is on the PowerPoint slides, which you will be able to access on our website shortly. Again, thank you to Rebecca, to Andy, to everybody who joined us today. I want to remind everybody again that the PowerPoint presentation and the recording will be posted on the WCA website. A quick announcement about some future in the boardrooms. In February, there will not be an in the boardroom due to the WCA legislative conference held at the end of February. And we will be back again in March, on March 26th, where our topic will be Act 264 and subdivision regulations. Again, if you have any topics you would like us to discuss as part of In the Boardroom, please feel free to reach out to Andy, Rebecca, or myself, and we will get those added to the list. But if not, thank you so much for joining us today, and hope you guys all have a great rest of your week.
Thanks, Sarah.